Good afternoon, friends. Let us dive into another case law, which is newly added into the Advocate on Record examination. The case law is SITA SOREN versus Union of India. It was decided on 4th March 2024. The bench comprises of Chief Justice Dr. D.Y. Chandrachud, Justice Ajay Kotrira, S. Bopanna, Justice M.M. Sundaresh, Justice P.S. Narasimha, Justice Jamshed B. Pardiwala, Justice Sanjay Kumar, Justice Manoj Mishra. The question involved before this bench was, does a legislature enjoy immunity from prosecution under Article 105, subclause 2, or under Article 194, subclause 2 of the Constitution of India for accepting bribes to vote in Parliament or a state legislative assembly? So this is the question. I am repeating the question. Does a legislator enjoy immunity from prosecution under Article 105, subclause 2 or Article 194, subclause 2 of the Constitution of India for accepting bribes to vote in Parliament or a state legislative assembly? Now, let us dive into factual background of the case. In 2012, the Election Commission of India released a notification to fill up 2 vacant seats in the Rajya Sabha from Jharkhand. The election was stopped as evidence emerged that the integrity of the election had been compromised. A CBI investigation found that the petitioner, a member of the Jharkhand Legislative Assembly, had demanded a payment of 50 lakh from the Rajya Sabha candidate for proposing his nomination and an additional 1 crore for voting in his favor, which was duly paid. The petitioner was charged with bribery and criminal conspiracy under sections 171E and 120B of the Indian Penal Code 1860, respectively, and criminal misconduct under section 13, subclause 1D of the Prevention of Corruption Act 1988. Crucially, it emerged that while petitioner was accused of receiving a bribe from one candidate for casting her vote in his favor, she had instead voted in favor of another candidate. In the Jharkhand High Court, the petitioner sought to quash proceedings against her by relying on the 5-judge constitutional bench decision in P.V. Narasimha Rao. 2 members of the parliament were accused of accepting bribes in this case to vote against a no confidence motion in the Lok Sabha, and the Supreme Court held that the immunity from criminal prosecution provided to parliamentarians under Article 105, subclause 2 of the Constitution of India extended not only to anything said or any vote given, but also to acts connected to the speech or vote in the legislature. On 17th February 2014, the Jharkhand High Court rejected the plea to quash proceedings against the petitioner. The petitioner subsequently appealed to the Supreme Court, where the correctness of the judgment in P.V. Narasimha Rao was questioned. Therefore, the petitioner's case was referred to a seven-judge bench. The petitioner contended that the P.V. Narasimha Rao judgment was correct, as it was crucial for safeguarding legislatures from coercion. They highlighted the importance of providing absolute protection to legislators for actions done in the course of their legislative duty. The respondent, Union of India, contended that this immunity should not cover activities that disrupt the legislative process or involve bribery. As such behavior has no room in the functioning democracy. Now, let us go to the decision of the Supreme Court. The Supreme Court unanimously held that legislators are not entitled to immunity under Article 105, subclause 2, and under Article 194, subclause 2 of the Constitution of India for engaging in acts of bribery. This seven-judge bench overturned the judgment in P.V. Narasimha Rao. Honorable Supreme Court established a dual criteria for determining when lawmakers could be granted immunity under Article 105, subclause 2 and Article 194, subclause 2 of the Constitution. First, immunity applied when the activity pertained to a collective function of the legislature. And secondly, the action in question must be inherently linked to the fulfillment of the duty of a legislator. The judgment was authored by Honorable Chief Justice D.Y. Chandrachud. Now, let us dive into reasons for the decision. Parliamentary privileges in India. Honorable Supreme Court held that Article 105, subclause 1 and subclause 2 of the Constitution guarantees freedom of speech in Parliament, which is essential for the functioning of Parliament. The court observed that Article 105, subclause 3 allows Parliament to legislate on immunities within constitutional limits. Without legislation, Parliament can claim only those immunities that the House of Commons of the United Kingdom possessed at the time of commencement of the Constitution of India. And Parliament is not the sole judge to decide on its privileges. The court held that members of the House of the Parliament or legislature cannot claim any privilege or immunity unconnected with the functioning of the House. Now, secondly, bribery is not protected by parliamentary privilege. The Honorable Supreme Court held that privileges of the House, its members, and committees extend beyond specific locations or acts. Speeches made in Parliament or legislature are immune from court proceedings. Article 105 and Article 194 aim to foster fearless debate free from third-party influence, while the majority in P.V. Narasimha Rao interpreted the phrase in respect of in Section 105 of the Constitution broadly, linking it to anything related to votes or speeches by legislators. The Honorable Supreme in the present case disagreed and restricted the scope of privileges to matters directly connected to the votes or speeches. The Supreme Court found that bribery undermines the core principles of democracy and is not immune from Article 105, subclause 2. Members involved can face prosecution for bribery. The Honorable Supreme Court clarified that bribery is not within the scope of parliamentary immunity. Such crimes do not relate to the essential functions of the legislator and can be prosecuted by criminal courts despite possible contempt proceedings by the House. Stage at which offense of bribery crystallizes. The Honorable Supreme Court held that the offense of bribery is committed upon the acceptance or agreement to accept money, regardless of whether the promised action is carried out. Bribery is deemed complete upon the exchange of legal gratification, irrespective of how the legislator ultimately votes. So this is all about this video. Friends, enjoy my videos and don't forget to like, share, and subscribe. God bless you all.